Hello, good afternoon and good morning to everyone, and welcome to our webinar today. I'm Nopama Thammathiladecho, a counsel from Tiliki and Gibbon International. And today I'm really glad that we have this webinar on the ship arrest, that we have the distinguished speakers from several jurisdictions, such as Mr. Clyde Efton, who's the arbitrator from London, the London Maritime Arbitrator Association, and Ms. Tan Hui Singh, our Singaporean lawyer who handles shipping and maritime cases for more than 25 years, and our colleagues from Tiliki, Vietnam, Mr. Kiang Hong Bak. Okay, before I present or introduce their experience in detail, I like to thank you, Bangkok Ship Owner and Agent Association, who's very kind to co-host this webinar with Tiliki and Gibbons. And also, we will have the each speaker present their presentation from the perspective of English arbitrator, then go to Singapore lawyer, and our Vietnam's lawyer and myself will present the issue of the ship arrest under Thai law. So I will be the moderator and the speaker altogether. So, and during the presentation, if any participant have any questions, you can also send us your question to the message box that have the icon, question mark icon. And after the presentation, we will open the floor for you to ask the question as well. So I like again to thank you and really appreciated our distinguished speaker today, that they devoted their time to join this webinar. I haven't heard about the ship arrest webinar in Thailand, I think more than 15 years already. So this will be the 15 years webinar on the ship arrest in Thailand. So, and I see that so many, almost I think 65 participants from several jurisdictions sign up for this webinar, ranging from the ship owners, ship agents, and some of the P&I Clubs, both in Thailand and internationally. And thank you for your participation today. First, I'd like to introduce you to our first speaker, Mr. Clyde Efton. He is the English arbitrator who have more than 30 years as the arbitrator handling this shipping disputes, and he learned law from Cambridge. So you will have his perspective concerning the ship arrest today. And then Tan Hui Singh will present her presentation. Tan Hui Singh graduated her law from the University of Bristol, and then have the degree, master degree from the in maritime law from the University of Southampton. I know Tan Hui Singh for more than 15 years already, and I'm glad that she joins our panel today. She has the experience and been engaged by P&I Clubs, and she also worked for P&I Club for several years and also handles shipping and maritime case in Singapore. Okay, so for our Vietnamese lawyers, our colleague Kiang Hong Bak. He graduated from LLB from and LLM from Diplomatic Academy of Vietnam. So I like to give the floor to Mr. Clyde Efton first. Okay, the floor is for you. Thank you.
Thank you very much, and hopefully my slides will shortly come on screen. Let me start by expressing my thanks to the Bangkok ship owners and ship agents and Tilaki and Gibbons for inviting me to join you this morning in speaking really of the relationship between London arbitration and ship arrests. First slide, please. Next slide. The important point, I think, that I'd like to start by making, and which is really behind this webinar, is that there's no point in having a good claim or even having an arbitration award in your hand if it can't be enforced or collected. And so the benefit of having security for a claim is very clear and very obvious. Next slide, please. What I think is surprising to some people is that although security is obtained to satisfy an arbitration award, it's generally not ordered by arbitrators, but is obtained by taking action independently by the parties. And if we can complete this slide, please. And that is normally achieved by arrest of ships, next click, arrest of bunkers, next click, arrest of bank accounts or other assets, or next click, freezing orders. So in a sense, where arbitrators don't have the power to order security, I'm really in the way of a warm-up act for the lawyers who follow, because the speakers who follow me are the ones who will be able mostly to assist you in obtaining security for your claims. Next slide, please. Arbitrators have very limited powers to order security, and I think that this sometimes surprises people. Under the Arbitration Act and the LMAA terms that apply to most London maritime arbitrations, we cannot order the arrest of a vessel. And generally, we can't order that a party provides security for a claim. In fact, usually we don't even know whether a claimant has security in an arbitration that we are dealing with, and we don't usually know if security is obtained during the course of that arbitration. Next slide, please. So why is it that the arbitrator's power to order arrest is so limited? Next click. The important point, I think, is that as arbitrators, we don't have legal or physical control over ships or the bunkers on ships. Next click. We have very little means of exerting control over ships, because the control over a ship is exercised by the port authorities or the courts in the place where the ship is located. So if we in London make an order that security be put up by an arrest of a ship, there's very little that we can do to police it. So this is why when you are looking for security, you have to go to the lawyers where the asset is located. Next click, please. Now, some people sometimes say, well, we've heard about emergency arbitrator powers. Might that be something that an arbitrator can use? Well, as the next click will show, the position is really no different. In London, under the LMAA terms, we don't have provision for emergency arbitrators, but the point remains the same, that an emergency arbitrator still would not have any control or influence over the movement or the detention of ships. Next slide, please. We have some limited powers as arbitrators to order security for costs. That is where a claimant starts a claim, the respondent may apply to us that a security be put up for the legal costs. And sometimes we may make conditional awards. We may, for example, order that the freight be paid by a charterer, but on the condition that the owner deposits security for any cross claims that the charterers may have. But I stress that our powers to order security for the actual claim are very, very limited to the point that they really don't exist at all. And that really is what makes the arresterships so important, even though it may take place a long way away from the seat of the arbitration, whether that be in London, in Singapore, Hong Kong, or anywhere. Next slide, please. Nevertheless, there is an important connection between arbitration and security. For example, there may be a dispute as to which is the proper place for a claim to be heard. Quite often, when a ship is arrested, the terms of the security that's provided may itself resolve that dispute, or it may create, by the agreement of the parties, jurisdiction of the arbitration tribunal. And particularly where P&I Clubs put up security, it's very common to find that they put up security, but on the basis that the claim is pursued in London arbitration. So there, the security is itself creating the jurisdiction in which the claim will be heard and determined. An important point at all as well that connects security and arbitration is that if you obtain security, you need to be very careful to identify the claims that the security is covering. Obviously, you want the security to cover the claims that you're referring to arbitration. Now, it may be that you would therefore want to specify what those claims are, the contract, the bill of lading number. But it may also be that if you're anticipating that further claims may arise in the future, that you will want to make that clear in the security document itself, and so reserve the right to bring further claims and seek further security in the future. So this connection between the security and the arbitration is important because the security is there to secure the claims that you're looking to pursue in arbitration. Next slide, please. From my experience over the years, I raise these as points of concern that should be kept in mind when one is looking to arrest a ship. And they may be points that the lawyers who speak after me will look to comment on. The first question I put here is, if you arrest a ship and obtain security, do the proceedings come to an end? Once the security has been obtained, do you then move off to London or Singapore and forget where you arrested the ship? Well, an important point to be made here is if you try not only to obtain security, but also try to pursue the claim itself in the place that you arrest, you may be in breach of the arbitration clause of the contract that you are looking to secure. And that may mean that there is what we call an anti-suit injunction brought in the English courts, by which an order is made by the English court that you stop your action outside London because you've agreed that that claim will be pursued, but only in London. Now, you may feel, well, what does it matter if the High Court in England issues an order saying that I shouldn't pursue my claim locally? I feel I have an advantage in pursuing it locally, and I'm going to do that. Well, the answer to that is the English court can police orders for anti-suit injunctions, so that if, for example, you came to visit the United Kingdom, you could actually be put in prison for contempt of court by ignoring a High Court injunction that you stop your claim and pursue it only in arbitration. Another important reason to consider whether the claim is brought to an end once the security is obtained is that it may be in some jurisdictions that if at the end of the case for which you've obtained security, it's found that your claim is wrong, you had a bad claim, the innocent party may be able to go back to the court where you were arrested and pursue a claim against you for wrongful arrest in that court. So it's important in those circumstances to know that you are terminating the action where you've brought the arrest to avoid that risk. And an interesting final point that I raise here arises from a case that is very recent, in June 2021, last month, where the arbitration tribunal, it was actually a court action, but by comparison, it was held that an arbitration tribunal might be able to award damages for wrongful arrest in the arbitration proceedings. So arrest is a wonderful thing, but one has to bear in mind that it isn't always a one-way course of action, and it may be that if the arrest is found to be wrongful, either because the claim has no merit or because, as in the case that is on your screen, the ship that was arrested was the wrong ship, that you may be exposing yourself to claims in damages in arbitration. So this really brings my presentation to its conclusion. The point being that we as arbitrators may make a claim in your favour, but it is the lawyers who speak next who will be able to help you to obtain security for those claims. Next slide, please. Thank you very much for your attention, and I look forward with great interest to listening to the speakers who follow. Thank you.
Yes, thank you, Clyde, for your insights, information as the arbitrator from London. And I like to give the floor to you, to Ms. Tan Hui Singh, as the partner from Dennis Matthew Shipping Lawyers, to sharing her experience regarding the ship arrest in Singapore, where I think that would be the place that there will be a lot of ship arrest in this region. Please, Hui Singh.
Thank you, Mu, for your introduction. Good afternoon, everybody. I'll just share my screen. First of all, sorry, give me a minute. Okay, I'll share my screen. I hope everybody can see my screen. Yes, thank you, Mo. Thank you for your kind introduction, and I thank also the ship owners, the Bangkok Ship Owners Association, for inviting me to speak today. I'm very glad to share my experience from Singapore. And so I'll just dive straight into the subject matter because I think we don't have very much time. But just as a preamble, I think arrest in Singapore is basically quite straightforward. I don't know whether any of the attendees today have experienced arrest, whether as a claimant or whether as a ship that has been arrested. But it'd be interesting to hear from you later. But there are a couple of new developments in Singapore now because of COVID. Recently, because of COVID, what we used to do previously, which was to attend on board a ship to physically serve the papers, we don't do that. We don't need to do that anymore. So now it's much easier. We just need to serve the documents on the agent and then notify the master and owner by either email or fax. So we have done away for the time being with the physical attendance. And we used to need the arresting party to post a security guard on board physically. That was during the physical attendance time. But again, because of COVID, it was felt that it was a bit dangerous to expose a security guard on board. So we've also done away with that. And so just to keep regular checks, the arresting party, usually the solicitor, will do a regular check every day to make sure that ship is still in port. Because as you're well aware, ships do break arrests. So we need to, whilst we cannot physically restrain ships, we would, just have to make sure that the ship is still in town and hasn't sailed away. Now, what are the claims that you can arrest for? Up on the slide, it's not an exhaustive list, but it's just I've got captured most of the claims here, and these are examples of claims that you can arrest for, types of claim you can arrest in Singapore. A full list of these claims is set out in the High Court Admiralty Jurisdiction Act, so it's actually a list per law. So first of all, you can see on the top left, you can have a claim for possession or ownership of the vessel. You can have a claim for mortgage. So frequently, bank financiers would invoke here this right of arrest. You could have a claim for damage done to ship or received by ship. So these are usually collision cases. I have claim for injury, personal injury or loss of life. Claim for loss or damage to goods carried on board. And then second row, you can have a claim for agreement arising relating to carriage of goods, use or hire of ship. And this is typically the limb that cargo claimants will invoke, or charter hire claims. So it will usually fall within this heading. Claim for towage of ship. There's also claim for goods and materials supplied to the ship for operation. So bunker suppliers will usually use this head of claim, or physical suppliers of equipment to ship. Ship repairers as well. So shipyards again will also come to use this claim. And then we also have claim by master for crew wages. So this is just a list of type of claims that you can arrest a ship for. Now, as Clive touched on earlier, and I thank you for bringing up the point, when you arrest a ship, what you're in fact doing is grounding jurisdiction for the claim. You obviously arrest to get security, but when you arrest in a certain place, particularly, for example, in the case of Singapore, you're actually saying to the Singapore court, you have jurisdiction because the ship is here physically in the Singapore court, and the claim that I'm asking for, it falls within one of these boxes here for which the court has jurisdiction. Now, it gets a little bit trickier when your claim may have an arbitration clause. Now, in Singapore, you can arrest a vessel to get security to support an international arbitration. So in that sense, it goes very well with arbitrations. So if you have, for example, a London arbitration clause in your charter party and the vessel calls in Singapore, then you can arrest in Singapore and then you get security to secure your arbitration proceedings that's ongoing in London. For other cases, if you have a contract that refers to, for example, proceedings in Thailand, court action in Thailand, then unfortunately you cannot arrest for court proceedings in a foreign jurisdiction. So when you deal with arrest here, you have to be very careful in Singapore what you are going for. Are you trying to ground the jurisdiction here in Singapore, or are you going straight for security? You have to make that very clear. Now, that presupposes, let's say if you're grounding security in Singapore, your jurisdiction in Singapore, then what you have to do is obviously after you get security, you run the whole action to the end, and then you get judgment and you can enforce on the security that you got earlier on when you arrested the vessel. Now, say for example, you have a judgment elsewhere, and then the ship happens to call in Singapore. Then the question would be, can you arrest for to enforce the foreign judgment? Now, technically, the answer is yes, but first of all, you must check that the judgment touches on one of these types of claims here. So again, when you're arresting because we're invoking the jurisdiction of court for the types of claim, you have to come back and cross-check to see whether your claim falls within one of these types for which you can arrest a ship. Now, that is straightforward when you have a judgment, but if you have a settlement agreement, that gets a little bit trickier. And settlement agreements, the position taken in law, in case law in Singapore is that the settlement merges into the agreement, and so your rights goes into the settlement agreement, and your rights do not retain under these types of claims we have here. So typically when settlement agreements are drafted for types of claim, for example, for charter party outstanding hire, or for claim with crew claims, or for construction or repair of ship claims, such settlement agreements have to be drafted very carefully, because if you want to retain your rights to arrest, you have to make that very clear in the settlement agreement, and you have to have a fallback position. So those are little bits which trip up litigants. So settlement agreements, just to emphasize, please approach it with a lot of care. Now, I've talked about types of claim for which you can arrest. Now I'm going to talk about the types of ships that you can arrest for. The three types of ships here. So the first type is the ship, the actual ship that caused the damage. That's quite straightforward, because what you need to do is you know which ship, and typically you have to do a check to make sure that owner of the ship is the party that was that caused the damage. We call this person a person liable in personam. This person may be a human person, but typically it's a company, it's a corporate person. So it will be that ship that you're looking at, and you have to be sure that the owner of that ship was the actual party that caused the damage. Now, the second types of ship you can arrest is what we call a sister ship. This means it is another ship, not the ship that caused the damage, but it's another ship, but it is owned by the same party who is liable in personam, the party that was responsible for the claim. And in that sense, we're looking at the registered ownership, meaning it must be the same registered owner of the first ship that caused the damage, and also the second ship that you want to go after. So things like group ownership, that is not good enough. Companies who are managers or commercial operators, again, that's not good enough, because we're looking at what we call a real sister, same parent, same registered ownership. Now, the third type of ship that you can arrest is a ship that is owned by the person who is liable, meaning it is not the actual ship that caused the damage, but let's say the owner of the ship has another ship. And I'll give you an example, and so it becomes very clear, because a very easy example will be like charterers. So for example, in a time charter, you know that the charterer will contract for bunkers, purchase bunkers for the ship that he has chartered, but then he doesn't pay. So obviously you can't arrest the ship that took bunkers, because that doesn't belong to the charterer. So then what you need to do is find out whether the charterer owns other ships. Then you can go after the charterer's ships. So that's for the third category. Now that we've dealt with ships, okay, I'll look at the things, just some things to consider. I put up here 3 points: jurisdiction, disclosure, and security wording. Jurisdiction I touched on a little bit earlier. Basically, just to recap, when you arrest in Singapore, you are seizing Singapore as a jurisdiction. And you have to ask yourself, are you entitled to do so, first of all? Because is there going to be a challenge in jurisdiction? Because if you're going to get a challenge, then you have to, then at that point in time, consider point number 3, which is security wording. Because as Clive mentioned also, you have to be sure that your security wording covers what the claim is about. So jurisdiction, yes, the vessel is physically in port. The claim falls within one of the headings, subject matters that you can claim for, but then does Singapore court really have the jurisdiction? Or perhaps you're just arresting to get security, in which case we're not too concerned about using Singapore to proceed for the whole case in Singapore. As I mentioned earlier, I'll just remind everybody that you can get security for international arbitration in Singapore, but you cannot arrest in Singapore to secure or support a court action in a foreign country. For example, a court action in Thailand, we cannot arrest to get security to support that. Now, the second point here I want to highlight is disclosure. In Singapore, we've moved to the point where full and frank disclosure of the whole case and background leading to the claim is very important. In this respect, we have moved away slightly from our older position, which is the English position of arresting as a right. Now, the affidavits in my years of practice has grown. When I first started practice, you know, you can literally draft an affidavit for arrest within half an hour. You just have to state what ship, that you're sure that the party you're going after is liable in personam, and then you got the right ship, it's in port. You have the claim, you quantify it a little bit, and then you go ahead and file the affidavit and you arrest the ship. But now the affidavit requirement is very tedious, but it helps because it actually makes the applicant for arrest think through. And so in the affidavit where expected the party applying for arrest is expected to include even any defenses that the defendant may have, or any objections the defendant may have raised previously to demands, because the court in Singapore wants to know exactly what it is leading to arrest. And so failure of full disclosure becomes a technical breach, in fact, which may allow the ship owner to apply to set aside the arrest. So usually we are very careful here when drafting the affidavit leading arrest. We will ask for, as lawyers, we ask for the full details leading up to the claim. Now, as security, we mentioned earlier that you want to be securing the claim itself. Clyde mentioned that security, no, just sorry, I just wish to firstly highlight that security wording does not necessarily ground jurisdiction, meaning that you're getting security for the claim, but it doesn't follow that you're making the jurisdiction agreement for the claim in the security agreement. But you can also word it in such a way that it is also an agreement to in the security wording to say where the claim should take place. But these are actually two independent things, security for the claim and where the claim should actually happen. That's why I mentioned earlier we can we can arrest in Singapore, get the security to support foreign arbitration proceedings. Now, the security that we typically agree to in Singapore, which is acceptable, it can be paid in, can be cash paid into court, or it could be a letter of undertaking from P&I Club, or a banker's guarantee. Typically, LOUs from P&I Clubs are the most popular means because monies don't have to change hand. And when you're getting security, you must consider what you want, what is your claim, because you want to cover the principal amount of your claim, the actual claim itself, plus interest and costs. Now, interest is typically calculated at 5.33% per annum of the actual claim. And we run this amount for 3 years because the argument is that this 3 years is about the time it takes to start and end the claim. So you want to make sure that you're not out of pocket in terms of interest for this period of time. And legal costs. Singapore allows party and party costs, which is not the full amount you pay to your lawyer, but roughly about 2/3 of what you pay to your lawyer. So in terms of wording, you have to word your security to see where you're going to cover, where you're going to litigate, and make sure that it covers the claim finally. Because at the end of the day, you want to be sure that if there's any dispute to jurisdiction, the security covers the claim even if the action gets stayed in Singapore. And from the claimant's perspective, therefore, you would ask for security that is as widely worded as possible. And a lot of wordings that we recommend and we see, it will be for security to cover an unappealable judgment or a final arbitration award. And so you're covering both ends. That's from the claimant's perspective. Obviously, from the ship's perspective, you don't want it to be so wide. So very early on, sometimes, even as parties are trying to agree on the security wording, you will have parties trying to also nail down jurisdiction for the claim. And this is particularly so when it is not a charter party type, it is not contractual. And so it's open to interpretation, and that's where the lawyers come in and will try to advise on that. This goes into a lot of detail, which I try not to handle here, but maybe I'll be happy to take any questions if it arises. So thank you very much, everyone, for listening. I'll see you later. Okay, let me just try to.
Thank you, Hui Sing, for the informative and good information of your ship arrest experience sharing with our participants. So now we go to Vietnam concerning the ship arrest. So Kiang, you can share your slide and exchange your experience with the participant, please.
Yes, thank you. Do you see our slide? Can you see the slide that I said?
Yeah, full screen. Okay, we can see it.
Thank you. Hello, everyone. Yes, my name is Giang. I'm a attorney law in Vietnam, and today I will introduce about some basically regulation about the ship arrest in Vietnam. As you know, the first case in Vietnam about the arrest ship is happened in 1990, and from now, Vietnam have prepared for code and law to guide about the ship arrest in Vietnam, and most of legislation is corresponding to the international convention, and especially we have the maritime law and the ordinance on the procedure for the arrest ship. In Vietnam, how about what ground can be a ship arrested? And in fact, we have 4 basic grounds to arrest a ship. It is first is the maritime claims. The second is applied to the interim injunctions. The third is the enforce of a shipping judgment or a foreign arbitral award. And the fourth is the performance of a mutual legal assistance. And the main ground here today is about the maritime claims. Most of the claimants often rely on the maritime claim to arrest a ship. I will introduce about the first type. The first type is maritime claims. Maritime claims include two types of claim. The first is a maritime liens, and the other is other claim have about 17 claims. The maritime liens have 5 groups, as you see in the slide about the claim for the waste. The second is claim in respect of loss or personal injury occurring in the operation of the ship. The third is a claim for the ship joint use. The fourth is a claim for the reward, and the fifth is a claim by on the chart. In Vietnam, maritime lien is the priority when the court intend to apply the maritime lien. And in addition to the maritime liens, we have about 17 other claims to rely to arrest a ship, and among of the 17 claims, we can rely the most important that we can rely is the claim 14, claim 16, and claim 17 is a dispute to the ownership or the possession of the ship, or a ship mounted, and a dispute arising a contract between the claimant and the ship owner. About the procedure to arrest a ship based on the maritime claims is quite simple in Vietnam. Firstly, we can prepare a dossier. Include the most important thing in the dossier is that we need to verify the location of the ship, and then based on such information we can submit the dossier to the court where the shipyard is located. Based on our dossier, the court will have 48 hours to decide whether they agree or refuse our request. If they refuse to handle the case, we can appeal within 22 hours. And meanwhile, if they agree to our request, we can have 48 hours to pay the financial security to the court. And then based on our financial security, the court will issue a decision to arrest a ship, and the head of the seaport has responsible to enforce the court decision to arrest a ship, even when the ship owner file an appeal to the court decision. Yeah. I have some notes about some main point during to arrest the ship. The first is the timeline. In principle, we can arrest a ship within 30 days from the date on which the ship is arrested. And if you want to extend the timeline, you need to file a request or you need to start a civil suit at the court, and we need to obtain the interim injunction from the court to extend the timeline to arrest a ship. About the financial security, in general, the financial security will be calculated by the court, and it is equivalent to the possible loss or the damage resulting from the wrong arrest. In our experience, the court often rely on the damage or rely on the compensation that we claim in the request for arrest the ship to calculate the financial security, and the arresting party can provide the court with a bank guarantee or a deposit in a frozen account to prove the financial security. Similar to Singapore, in Vietnam we have the regulation to allow arrest of a sister ship. It means that we can arrest a ship and another ship, a ship and the sister ship, even when it has the same owner. Yeah. The second choice for the claimant to arrest a ship in Vietnam is that we can persuade an interim injunction at the court or the arbitration center. To proceed with the interim injunction, we need to file a statement of claim to the court, and the court, when during the civil court, we can file a request for applying the interim injunction. The purpose of this action is that to protect the evidence or preserve the evidence, means that we can arrest the ship. Basically, the procedure to arrest the ship by the second choice is similar to the maritime claims. It means that we can we need to submit a request for applying the interim injunction to the court where the seaport is located. And unlike the maritime claim, the court will have 3 days to decide whether they agree to arrest the ship or not. And similar to the maritime claim, if the court agree to arrest the ship, they will issue a decision and transfer it to the director of the seaport. And the director of the seaport have 20 hours to arrest the ship. The third choice for the claimant to arrest a ship in Vietnam is that the enforcement of a civil judgment or a foreign arbitration award. It means that in the third option, we need to have a judgment, or we need to have a foreign arbitration award, and then we will require the civil judgment enforcement body to enforce the judgment to arrest the ship. About the procedure in the third option, unlike the maritime claim or apply the interim injunction, in this option, we need to prepare the request and submit it to the enforcement agency first. After receiving our dossier, the enforcement agency will review and transfer our request to the court, and the court will decide to agree or refuse our request for arrest the ship. And similar to option above, the court will require us to pay the financial security first, and then they can issue the decision to arrest the ship, and the director of the seaport will have responsible to arrest the ship, even when the ship owner appear against the court decision. The first choice for the claimant to require arrest the ship is the performance of the international judicial assistance, and in Vietnam, it's rarely case to apply the first choice, but in principle, a Vietnamese court can require a foreign court to arrest a seagoing ship based on the treaty which the Vietnam is a contracting party. In contrary, Vietnamese court shall exercise jurisdiction given by the foreign court to arrest a ship in Vietnam. Notably, Vietnamese court may refuse to arrest a ship if the case infringes the Vietnamese sovereignty or falls beyond the competence of the Vietnamese court. We have present 4 choices to arrest the ship in Vietnam, and we can say about the experience, our experience in Vietnam. We had an arrest ship case last year, 2020, and in this case, our client purchased a ship X from a party. In the contract, the ship X were not mortgaged in any country, but later, our client found out the ship X were mortgaged in Nigeria and were arrested in Nigeria. So our clients wanted to party A to pay their damage due to the breach of the contract. Based on the contract, our client sued against the party A at the arbitration in London, and they obtained a favorable arbitral award. However, they found that the party A also have a ship Z in Vietnam. They cannot arrest the ship X in Nigeria, so they decide to arrest the ship Z in Vietnam for 2 purposes. The first is to put pressure on party to pay the damage, and the second is enforce the arbitral award in Vietnam. However, in this case, we have 2 problems. In fact, in principle, the client have 2 options to arrest the ship. The first option is they arrest the ship based on the maritime claims, and the second option is they proceed with the recognition and enforcement of the foreign arbitral award. But if they want to proceed the recognition and enforcement the award, it can take a lot of time for us to complete the recognition, and a problem that we cannot arrest a ship. We cannot pursue an interim injunction to arrest a ship during the recognition and the enforcement of a award. So we advise client to arrest the ship based on the maritime claims. However, there is a risk that in Vietnam, the court will not agree to arrest a ship if they found that the claimant has a foreign arbitral award, and they will request the claimant to process the recognition first and to enforce the award letter to arrest the ship. So finally, we try to arrest the ship based on the maritime claim, but the court did not agree. So our case was not successful in this option. So here is about our introduction, some legal ground to arrest the ship in Vietnam. And do you have any question you can raise? Yes, thank you.
Okay. Again, you can stop your presentation, and thank you for your presentation.
Yeah.
So, okay, right now I will share my slide for the ship arrest in Thailand. You can see it, right? Okay. For ship arrest in Thailand, there are 3 laws that related for the ship arrest in Thailand. As I told you that the most efficient ship arrest in Thailand that will go to the Ship Arrest Act, right? So this one is the one that we experience that we can obtain the court order for the arrest warrant very quickly within 1 day. But the problem that we facing when we assist client for the ship arrest in Thailand is that First, because for the claimant, for the creditor who want to file the ship arrest in Thailand, they must have the domicile in Thailand. What kind of the domicile? Can the creditor have the agent and establish the domicile in Thailand? That is something is very, very difficult requirement for the ship arrest in Thailand here. And secondly, the creditor will need to refer to the maritime claims, either tort or the wrongful act or the contract concerning the maritime claims. I will come back to the requirement for the domicile in Thailand. This is the most difficult things that I think that we try to solve for several years. First, we try to transfer. Our client have the maritime claim. Our clients was the bunker provider to the ship, right? And then this is considered as the maritime claim. However, our clients was the South Korean company. So the problem that our client has no branch in Thailand, have no agent in Thailand. So at that time, what we try to do that our client assigns the maritime claims to another company newly established in Thailand, and then pursue the ship arrest in Thai court. For the first option, yet unfortunately not successful. And after that, we try the second choice, that client agreed to establish the branch of South Korean company in Thailand. For this one, I can say that we successfully arrest the ship for our client. So we have to be very creative how to establish the local domiciles to allow our client as the creditor to arrest the ship in Thai court. So this is something that I think that is even though we're saying that we go to the court one day, file the application for the ship arrest, yes, finish. But the preparation before we go to the court, how we establish the local domiciles is something that sometimes for that case, for South Korean case, it takes like 6 months before we can establish the branch for this company to arrest the ship. Okay. Yes, in Thailand, you can the creditor can file the ship arrest application for the debtor ship or the ship that the debtors has the possession, and also can arrest the sister ship that allowed. So it means that the ship that your client want to arrest, the debtor need not to be the owner of the vessel, right? And another thing that require you in the ship arrest application, we have to inform and provide the evidence to the court that this ship will present in Thailand, or use the AIS map to show the client that the ship already in Thai water. And another two laws that you can arrest the ship is the Arbitration Act and the Civil Procedure Code. Okay. So I'm not going to repeat again about the maritime claims that you already know, right? So, but please understand that not only the claim based on the contract, the maritime or shipping contracts that allows you arrest the ship. It can be the wrongful acts like the ship collision or stealing of the bunker, something like that, that establish the fact that your client can pursue to arrest the ship in Thai court. So I give you the comparison, how we going to arrest the ship by these 3 laws, right? If your clients have the domicile in Thailand, regardless of their nationality, they can pursue the ship arrest. That's no problem. And the maritime claims is the requirement. And another big issue for the ship arrest that the bail or the deposit that we usually stated to the court in our application that how much money that our clients and the applicant going to deposit to the court. There is no guidance. That unfortunately they're very, very difficult. But the amount of the bail that I put here is according to my experience. And as you know that for Thailand, when you want to remit the fund more than 1.5 million baht, sometimes you have to declare several things, right? To the Bank of Thailand, while you remit a lot of money to Thailand. That's another delays thing when you want to proceed the ship arrest in Thailand. And why I get this amount of the bail to you, because we have filed several ship arrests. And if client think that, okay, that claim is not so big, usually I say that at least 1 million baht you need to put in the deposit. Otherwise, it is likely that the court will dismiss your application, because the court aware that, oh, the marine vessel, a lot of the value of the marine vessel and the loss opportunity of the vessel, something that is very high value. This is to prevent the wrongful ship arrest. And when my clients ask how we calculate, I asked my team to research for the previous Supreme Court president, how much the court require for the deposit when the court going to require the plaintiff or the claimant to put the deposit or bail. So we found that the number is around 0.3% of the claim amount. So this is something that if you consider to arrest the ship, not only the legal fee, but you have to consider the bail amount as well, right? And as we think said that we didn't take long to draft the ship arrest application, but the other thing that we have to prepare along is maybe maybe take longer than 1 day. In my experience, I think that the quickest that we can do is we have 2 days to prepare for the applications, and also client need to have the witness to be ready to go with our team to testify to the court. Because once we file the ship arrest application, the court will take like 3 hours to review our application, and after that, grant the order whether or not to arrest the ship or to dismiss our application. And it is ex parte hearing. Usually there is no, the court not going to inform the other side or the opposing party to join the hearing. It's easy like that. It's easy like that. But as I told you, many of my clients, they don't have the domicile in Thailand. So we have the second option for them. They can pursue the ship arrest through the civil court that I think it's similar to what Kiang already said, that we submit the complaint, the civil complaint, and together with the emergency, the request for the emergency injunction from the court. For this option, this second option, yet the difficult thing is that the court will have to consider whether or not your case have a possibility to win the case. That's difficult, you know, because you just file the complaint and the exhibit is one side, and the other the second difficulty, that how you prove to the court that is urgent, the urgency of the case. Usually we will inform the court that yes, the ship master on board, he can take away this ship, sail this ship out of Thai water at any time. So we successfully to claim for that in this kind of case. But usually it will start with the possibility to win the case. This is something that when clients choose to go to this way, we start with this thing. And another problem, that if the court think that this is not urgent, the court will dismiss your application request for the urgent hearing. And what happened? You can resubmit the request for the ship arrest for the interim measure for the normal process. For this thing seem to be difficult, because usually the court will invite the opposing party to object your request, and it cannot finish within one day. The court will allow the time for the opposing party to draft and submit the objection, usually 1 month. As you can see that most of the marine vessel, when they call to any port, usually they stay like even 3 days, a week, and then they leave the Thai water, right? And the third law for the ship arrest that you may consider, because most shipping agreements, charter party, there are arbitration clause, right? So Arbitration Act of Thailand, Section 16, allow that if the claimant want to obtain the interim relief, even before the claimant pursue the arbitration, the claimant can file the request to Thai court in order to obtain the interim reliefs. However, what are the requirements for the court to give the interim reliefs under this Arbitration Act? It comes back to the Civil Procedure Code. This means that you still have to prove the possibility to win the case, and secondly, the urgency to secure the debtor property. So that is just like tied together Arbitration Act and the Civil Procedure Code, right? But you have to be very, very careful, because to use the Arbitration Act to arrest the ship, it means that the ship owner have to be the debtor or the contractual party under that arbitration agreement. Right. This is something that is very important. Otherwise, the court will be very reluctant to arrest the ship. refer to the case, the maritime case in Hong Kong. This is something that I think Kiang already said. This case happened in 2014, and several shipping lawyers refer to this case when they think that what happened if you pursue the arbitration case concerning the shipping dispute, and then your client obtain the arbitral award from London, from Singapore, whatsoever. And in this case, the claimant obtained the arbitral award from London against the charterers. And this claimant want to invoke the want to arrest the ship of the charterer, the defendant in the case, in Hong Kong court. You see, in this case, the claimant filing for the ship arrest under the ship arrest law. This claimant didn't pursue the case by arrest the ship by enforce of the arbitral award. The application that the claimant draft is also referred to maritime claim, not as the means of enforcing the award. And the charterer, as the opposing party, object the request for the ship arrest by saying that, hey, no. The claimant, you cannot arrest the ship by this way, but because actually you have the hidden agenda to abuse the process, you actually want to enforce the award that you obtained from London. However, in this case, what the court looking or examining, the court found that the application that the plaintiff or the creditor filed in this case based on the maritime claim, that come back to the suggestion when Hui Sing present her presentation that you have to be very careful when you draft the application. You refer to the maritime claims. And this is separate from the enforcement of the arbitral awards. Different thing. Don't confusing and mix all together. And what happened? If this happened in Thailand, if this kind of thing happened in Thailand, in Thai court, I couldn't file the Thai court precedent regarding the ship arrest via the arbitral award. But my experience concerning my invention in the court, that this is based on my assumption. If this case happened, when you obtain the arbitral award from foreign country, you may try to file the ship arrest based on the ship arrest, but please highlight that this award derived from the maritime claims. I still believe that could be possible to arrest the ship, but that I think that I reserve this for my own opinion. So that's why I think it is really important when your lawyer draft the application for the ship arrest, whether or not it's based on the maritime claim, or you want to enforce the award, enforce the securities, is something that can give you a different end result. I received the inquiry from the participant. When we say that we arrest the ship, it means ship, not the cargo on the ship. We ever arrest the ship, and on the ship there were cargoes. What happened? In such kind of cases, the cargo owner can apply and or request the court to release the cargo. That is easy like that. And how about the release of the ship? Unfortunately for Thai court will not accept P&I Club letter of undertaking. So if you are the one who represent the ship owner, we will inform the ship owner or P&I Club that please prepare the bank guarantee issue in Thailand, or the cash that we can pay via the cashier check. So that's something for release of the ship is also not complicated issue here. Okay, so that all for the issue for the ship arrest in Thailand. Okay, any question? So some of our participants ask, is there any need for the deposit financial security by arresting party for arresting ship in Singapore? I think yes, right, Hui Sing?
Okay, let me just explain how it works here. There is no need to put up counter security, but the party applying for an arrest has to give a written undertaking that he will pay for all the expenses incurred during arrest. Because when the ship is under arrest, the sheriff, technically it is in the custody and control of the sheriff, and the sheriff needs to make sure that the crew on board has food, the ship has bunkers, there's water, and so the arresting party has to pay for this at the first instance. Obviously, he can recover from as part of the arrest costs later on, but at first instance, somebody has to pay for it. And in that sense, there is no counter security for the claim, because I know in some countries you have to put a counter security up to a certain percentage of your claim amount. There's no need in Singapore, but the arresting party needs to be able to say, yes, if the expenses for the arrest, keeping the ship, I will pay for that. And so typically what happens is it's an undertaking that the lawyer files in court. It's just a piece of paper, but it's on the understanding that the clients will back this up. And also what typically happens is when we first file an arrest application, and once you get the warrant, a deposit needs to be placed with the sheriff. So we will ask our clients for a deposit. Currently is about 10,000 Singapore dollars. And so you give the sheriff a check for that amount. It may or may not be used up. So if it's unused, it'll be returned. But if it's used, obviously, like I said earlier, the arresting party can make it as part of the claim in the whole claim against the ship.
Okay, so some of our participants want to know the statistic of the ship arrest application in each country. So I think that for Thailand is not a lot. We have like 5 to 10 cases yearly for the ship arrest application. However, for the ship arrest through the civil procedural case, that is something we cannot check. We can only check when and it's quite difficult because the ship arrest will finish when the party file the complaint. the court will extend the ship arrest until the court grant the first judgment. And that's why we can check only how many the ship arrest application filed under the Ship Arrest Act. But if the ship arrest filed under the Arbitration Act or the Civil Procedure Act, that's difficult. We cannot get a statistic for that. So I asked Kiang and Hui Sing and Clive, do you have any estimate number for the ship arrest application in your own country?
Okay, I'll go first. I don't have the statistics, and the court actually doesn't release it. But what I can say anecdotally is that obviously it has reduced over the definitely last year, and this year, but it's still going ahead. But I think it's probably reduced instead of, I would imagine we used to have in hundreds, but obviously it's come down significantly. I don't have the statistics, but one place to gauge is there's an open website, a Supreme Court of Singapore website. It doesn't show the ship arrests there, the number of arrests, but what it does show is the vessels that are currently under arrest, and that gives you roughly an idea. But it also depends on how quickly the vessels are released. So one trick we used to do was to look at the warrants of arrest number to see how many warrants of arrest were issued. And currently I'm looking at the website. It looks like it may just be warrants of arrest up to 15 at current stage. But again, it may not be reflective because some vessels get arrested, released very quickly. So it is not a complete gauge. Yeah.
Yes.
Yeah, Kiang.
Yes, similar to the Thailand and Singapore, there is no official statistic about the ship arrest in Vietnam, and we do not have about how many arrests to a ship. But I think that is a lot of the ship arrests in Vietnam corresponding to the Singapore or Thailand. Yeah.
Okay. Do you have any comments on the ship arrest in London, in UK? Clyde?
Well, the criteria for arrest is not too different to Singapore. Singapore was originally based on UK. The numbers now, we're certainly going to be less than Singapore for the reason that we have less ships calling in the UK, unfortunately. But it is a regular occurrence. Number-wise, I probably couldn't tell you. We might be looking at perhaps 50% of the Singapore level, but it certainly is not uncommon in the UK.
Okay, understand. Okay, another question regarding to Thai Ship Arrest Act, time to obtain the court order within 1 day. This 1 day time limit can request the court to extend or not. Okay, actually, when I say that the time when we file the ship arrest in Thai court, it take 1 day. It take 1 day in the court, and after the court grant the arrest order, within that same day, the court will email the order to the Marine Department to block the ship leaving Thai waters. Again, our work not finished like that, because we on the next day we have to go to the sheriff, or when we call the legal execution officer, to bring this court order to the vessel. So as Hui Sing said, we have to notify this court order to the shipmaster on the ship. That is another thing that we have to do in order to prevent the vessel leave Thai water. Okay. So I asked Clive the question regarding to the shipping and maritime arbitration, whether or not you the party would inform you concerning the ship arrest during the arbitration procedure?
No. Well, they're not obliged to. Usually they don't. Sometimes we get to learn about it because suddenly the correspondence between the parties becomes more aggressive when there has been an arrest. But very often we don't know. The only situation in which we might be told by the parties is if the parties are looking for an award that specifies that a payment is to be made out under the terms of a security that's been provided.
Okay, and another thing for the last question that we like to ask Clyde for the whether or not it's often did it often for the arbitrator to consider the anti-suit concerning the ship arrest, or it's uncommon in the arbitrations?
Well, mostly the applications are made to the High Court rather than to arbitrators. And the reason for that is that if an anti-suit injunction given by the court is ignored, then, as I mentioned, if the party comes to the UK, they will be in contempt of court and they may be arrested. But we are occasionally asked to make injunctions, including anti-suit injunctions. So the answer there is yes, but I think before people come to us to ask us for injunctions, they really need to check with their lawyers as to how effective an injunction from arbitrators will be rather than coming from the court.
Yes. Okay. So I think that's all. We really close to 4:30. So any speaker wish to have any additional comments on or want to share anything else? Otherwise, I will close this webinar. No? Anything?
Yeah, no.
No, just thank you everyone for their time.
Yes, indeed. Thank you.
Yeah.
Thank you.
Okay. Thank you, Clive, Hui Sing, and Kiang for sharing your experience and your time today with us and with our participants today. And I hope that we will have this kind of interesting shipping and maritime webinar in the future soon. Okay. Thank you very much, everyone. Thank you, participants. Bye-bye.
Thank you. Bye-bye. Yeah.